The brand equity of the New York Attorney General's office is currently in a state of technical insolvency, as the forensic inflow of criminal referrals targets the state's primary auditor of integrity.
This is that crazy fraud case that we all watched, we covered day by day. Almost the entire legal community recognized it as frivolous. Correct, no victims. The banks that he supposedly defrauded came on the witness stand and told the jury we would lend money to him again. The jury convicted him on all counts. The judge trebled the damages. He added interest, pre-judgment interest, post-judgment interest, that came to $500 million. The appellate court threw out the financial remedy. It threw out the $500 million that the court ordered him to pay. What it did not throw out is the finding of guilt, the determination that he and his family members are disqualified from operating their businesses in the state of New York, and their businesses are subject to a monitor, a retired federal judge, very well-respected woman, Barbara Jones, who is still the monitor of that, of all the Trump Organization properties in New York City. So that's what he's asking the highest court to dislodge, and I profoundly hope that the court does it.
We are performing a premium arbitrage audit on Letitia James, documenting 2 criminal referrals sent by Federal Housing Finance Agency Director Bill Pulte to the Department of Justice, alleging suspected homeowners insurance fraud across 3 states.
Once it does, his next move will be, well, since the whole case against me was thrown out, I want attorney's fees. And in my view, he'd be entitled to them.
Interesting. That's an interesting point. And the president also, they accused New York Attorney General Letitia James of targeting Trump for political purposes. We've seen the social media videos during her run. But this is what was said. This case is a clear example of unconstitutional selective enforcement. The reason here was pure politics, as Attorney General James' own statements make clear. Does that play any part in his argument?
It probably doesn't, because the judges in New York are popularly elected, and they understand the need. They usually don't go out and campaign, and they often don't have opposition, but sometimes they do. And they understand campaigning. Attorney General James, there's those famous clips of her where she's being interviewed by some young girls. Will you get Donald Trump for us? Oh, yes, I will. And then she makes other promises to go after him. There is no question that every evidence you look at of her behavior shows an intent to pursue him and pursue him alone. What is that called? Selective prosecution. That's the basis for this appeal.
I am Camilo Motado, and this is Camilo's House. As a certified public accountant focused on forensic verification, I approach every criminal referral like a management letter of significant deficiencies. Today, we are analyzing a scenario where the chief prosecutor is accused of phantom residency, claiming to live in Virginia while holding a sovereign mandate in New York, all to secure a lower insurance premium. The operational trigger for this crisis involves James's real estate portfolio in Norfolk, Virginia. According to the referrals, Letitia James may have falsified information to insurance companies in Florida and Illinois. In any risk-rated market, the presence of the asset owner is the primary driver of value. Insurance companies calculate their actuarial risk based on whether a home is owner-occupied or non-owner occupied. When you misrepresent a rental asset as a primary residence, you are performing premium arbitrage, securing a lower cost of capital through fraudulent disclosure. The audit trail provided by Director Bill Pulte includes primary source evidence that contradicts James's internal reporting. In the referral to the Southern District of Florida, Pulte cites an insurance application for a Fort Lauderdale-based company where James allegedly claimed her Virginia home would be unoccupied for only 5 months of the year. However, her own niece reportedly told a grand jury that she had been living in that home rent-free for 5 years. From a forensic accounting perspective, if the niece is in the house, the asset usage is non-owner occupied. Even more damaging is the occupancy variance reported to Allstate in Illinois. The referral alleges James claimed the Virginia home would only be occupied by one individual, yet neighbors have provided third-party verification that she was living there with 3 children. In the world of risk management, the density of occupation directly affects the liability profile of a property. By redacting the residence on her application, James was allegedly obscuring the true risk from her underwriters to defraud the insurer of the correct premium revenue. We must also audit the jurisdictional conflict of the Chief Law Enforcement Officer of New York. Under state law, the Attorney General is contractually required to be a resident of New York. If she was claiming her primary residence was in Virginia for insurance purposes, she has created an insolvent narrative. She cannot be vested in New York for her public salary while being vested in Virginia for her private insurance. This management override of ethics suggests she was cherry-picking jurisdictions to maximize her financial yield. The technicality dismissal of her previous mortgage fraud case in November 2025 by Judge Lindsay Halligan was a failure of judicial controls. That case was written off because the prosecutor was ruled to be improperly appointed, not because the fraud was non-existent. These new insurance fraud referrals are a new round of forensic testing. These are federal crimes that carry significant penalties, including asset forfeiture and prison time. Meanwhile, Donald Trump is currently appealing the conviction in the civil fraud case. While the appellate court threw out the massive $500 million financial remedy, the finding of guilt still stands. Trump's next operational move will likely be seeking attorney's fees on the basis of selective and vindictive prosecution. Judge Napolitano has noted that there is clear evidence of an intent to pursue him alone, which serves as the basis for this hostile appeal. My forensic verdict on the Letitia James insurance fraud referral is that we are witnessing a systemic management default. The evidence of falsified information on insurance applications is a material fact that requires a full-scale prosecution. You cannot audit the world for fraud while hiding your own liabilities in a Virginia shadow ledger. I want to hear from you. Do you think Donald Trump will win his appeal to get the conviction overturned and go after those millions in legal fees? Does occupancy fraud for lower insurance premiums constitute a removal-level offense for an attorney general? Let me know in the comments. Your perspective is the only audit that matters. I am Camilo Motado, and this is Camilo's House. Subscribe to stay informed on the numbers, the laws, and the truth behind the headlines. Stay safe.